I received a great question off the internet. I'm going to look down at my notes to read it to you. The question is, if I'm married and all my assets are either joint tenants with right to survivorship, right? That's real estate, or jointly owned in jointly owned accounts with my spouse, do I really need a trust, or do I need to engage in estate planning at all? That's a really good question, right? And the idea is, the answer is maybe not at first, if you're only concerned with what happens to your stuff after you pass away, right? If you're married and everything you have is jointly owned and it's titled properly as joint tenants with rights of survivorship or tenants by the entirety, what will happen is the first spouse who passes away, when the first spouse passes away, the surviving spouse will just kind of automatically own everything. It doesn't matter if anything's in a trust or what the will says. These joint ownership designations are very useful for that. But sometimes things don't happen the way we think they're going to happen, because sometimes instead of someone just passing away all of a sudden, instead they become incapacitated. And when they become incapacitated, it's much more helpful to have a full estate plan in place, because you have things like a well-written, durable power of attorney, or you have the assets in a trust, and whoever the successor trustee is can help manipulate those assets, right? Sometimes we want help paying for home health care and assisted living facility care, and maybe ultimately nursing home care. And without estate planning and without this trust planning, it can be really hard for me as a elder law attorney who does a lot of Medicaid asset protection planning to help people protect their assets, because they're just jointly titled and now someone's become incapacitated and I don't have a mechanism by which I can engage in asset protection. So you want to have the general estate planning, right? Just not only the trust, but you want the power of attorney and the healthcare server. You want to be able to designate who can make decisions for you, whether it's financially, whether it's signing contracts, or whether it's engaging in asset protection should you lose the ability to do that for yourself. Now, ultimately, you also want to engage in estate planning and probably utilize a revocable trust at the very least, because when both spouses pass away, then there's no one to co-own all this property with. And if you put it in someone else's name while you're alive and you need care within 5 years, you've disqualified yourself for some period of time. We might now be looking at a probate process. So when everyone has passed away, it's good to have everything in a trust, because the trust can control what happens. Avoiding court, avoiding the expense of court, avoiding having to hire another lawyer makes good, solid financial sense. And we're planning with estate planning, we plan for a lot of things that might not happen, that may not come to fruition. But if they do, you'll be very glad that you planned in the first place, or your heirs will be very glad that you planned in the first place, because it avoids a lot of heartaches, a lot of barriers, a lot of stumbling blocks, a lot of expenses by planning now, as opposed to just doing nothing and hoping for the best and hoping things work out the way we think they're going to work out. So hope that answers that question. Thank you very much for submitting it. I'm going to post this on the channel. And if you have any other questions you'd like to submit to me, if I think that if I get these questions a lot, I like to take them and post them on the internet for everyone to see and benefit from. If you are in Florida and would like to talk about estate planning, asset protection planning, Medicaid planning, or any other elder law matter, give us a call or visit us online at elderneedslaw.com. Thanks for watching.